Attorney Jordan Chiric of a St. Louis law firm is credited with creating the acronym PASS: Preparation, Anticipation, Selectivity, and Style. These are the elements key to a successful appellate advocacy. Preparation is an attorney's mastery of the record, the law, and the rules of the appellate court. Anticipation is a brief writer's effort to determine how to frame the issues and develop appellate strategy in a way that will best influence the judges who decide the case. Selectivity is about choosing the facts, events, and legal arguments likely to control the outcome, and style is the ability to persuade by writing and thinking well. This week, we're covering preparation. When it comes to preparation, it's all about 12 steps. The 12-step writing process, that is. Lawyers are inclined to act too quickly and think too little, if they ever think at all. A brief is not written even by a brilliant lawyer in a single afternoon. Before writing a brief, it is necessary to plot out the exact link of attack or defense fully. Gene Appleman, The Written Argument on Appeal. Before we dive into the first step of the process, let's hear a few words from the judges themselves about the writing process.
But if I were to go back and be a practicing lawyer, I would really discipline myself to start earlier. I mean, a self-imposed deadline, because now, a practicing lawyer can't do what I do, but on average, I probably do 25, 30 drafts of an opinion, and I could do more. But one of the things that I find, it's almost like peeling layers off as you write, and you clear up the writing. More points with respect to your issues start to become clarified. I will find my clerks will think that I'm in the 23rd, 24th draft and think, hey, we got to be done right now. And then I'll come with another concept. Just said, this has always bothered me here. Now that I've got everything else straightened around this is not clear. And the reason it's not clear is we haven't figured out exactly what we want to say. And now, most writers of briefs aren't going to have that amount of time to do that. But if you start early enough and then give yourself a chance to step back and then readdress it again, I think that the writing would clear up a bit. I mean, so often, I was a practitioner of that when I was a lawyer. Is that I drove too close to the deadline, and then I didn't have time to, sometimes even to get some of the noise out, and that results in a very distracting brief.
When you go about writing an article or a book, I'll let you take the sip first.
I can sip water and listen at the same time, contrary to what Lyndon Johnson thought.
How would you describe your writing process? How do you go about writing an article or a book? You get the germ of an idea.
You got to outline it first.
Do you?
Yeah, I always do. Yeah, I think you got it.
Does anything happen before you outline?
I think about it a lot.
Mm-hmm.
Oh, yeah. There has to be a lengthy germination process. You just don't sit down cold and say, I'm going to do this. Think about it. Think about it when you're driving home, when you're exercising at the gym. Ideas go through your head. Then when you think you have all of the ideas, all of the points you want to make, then you sit down and organize them. Say, what's the proper approach, what order to put them in, and so forth. And then just sit down and write, and that's the hardest part. Sit down and write.
How detailed do you like your outline to be?
Not very detailed.
No. Just the main proposition?
Main propositions.
And then when you actually sit down to write a draft, do you try to write briskly?
I don't write briskly. I write painfully. And I do each paragraph one at a time and try to make the point clearly there and then go through it again and again. That's what I'm doing.
And leave plenty of time for editing.
Oh, yeah. Well, to the extent you have. Sometimes, if it's the end of the term, it's in June and you're writing a dissent, you very often don't have much time. It has to go to the printer.
You haven't written briefs in a long time, but is your sense that the best brief writers finish They have a good polished draft well before the brief is due, and then refine it?
I think the best briefs are written that way.
Step number 1, set a timeline. You'll become a better writer if you habitually establish similar benchmarks. The process I'm about to share, setting timelines for the stages of your work, comes from the book Making Your Case, The Art of Persuading Judges by Justice Scalia and Brian Garner. There are various stages of writing: developing and gathering ideas, ordering them in an outline, drafting the text, letting the text cool, revising the text, and editing and re-editing the final product. If the only deadline you set for yourself is the filing date, you will not give each of these stages the time it deserves. Establish a schedule for completing each stage. Let's say it's Wednesday now and you have a brief due to be filed next Wednesday afternoon. You have to establish intermediate deadlines, and you must work backward from the filing date to set them. You want a clean, full draft first thing Monday morning so that you'll have time to show the brief to colleagues, amplify or trim back the ideas here and there, vet the citations, and generally polish the brief. That means you'll probably want to write the brief Saturday afternoon. Ideally, the first draft of a brief is written in as few sittings as possible. That means you'll want an outline by Saturday at noon. You're planning to use Sunday as a cooling off period. And that means you'll be preparing your outline in earnest late Saturday morning, from 11 o'clock, say, until noon. And that, in turn, means that you have until 11 a.m. Saturday to master the file, read and analyze the cases, take notes, and ponder the problem. Hence your intermediate deadlines. Wednesday through Saturday morning, research, take copious notes, brainstorm the questions presented. Late Saturday morning, prepare an outline consisting of complete sentences, the beginning of your argumentative headings. Saturday afternoon, sit down to write, blocking out all interruptions as best you can. Flesh out the brief using the skeletal headlines that you've already devised. Monday, revise, preferably with the help of others. Prepare the table of authorities and the table of contents. Tuesday, polish, verify all citations, edit and re-edit, verify all page references in the tables. The process we've just outlined may sound mechanistic, but it works. You'll find you'll become a much more efficient writer if you habitually establish similar benchmarks. Of course, the project is collapsible to an hour or expandable to a year-long writing project. Step number 2, learn the rules. Review the applicable statutes and rules governing appellate procedure in whatever court you're in. Pay particular attention to deadlines, requirements for ordering transcripts or making record designations, requirements for form and content of briefs, and other rules governing the actual practice before the court. To do this, check the court's website. Step 3, familiarize yourself with the case. Review the record. As you review it, start thinking about issues to raise on appeal. Many records consist of the indictment or complaint, transcripts, motions, and briefs in support of motions, the court's opinion and the order, the notice, and the granting of the appeal. The order is a good place to start. Make a list of possible issues and include in the list everything that looks like it has any chance of success. Eventually, you'll narrow the list down to no more than 3 or 4 issues. Step number 4, learn the record cold. The appellate court's job is to review the record for errors. If something is not in the record, it cannot be reviewed on appeal. Knowing the record is often more important than knowing the law. In real-life appellate advocacy, the record plays a key role, and a lawyer's mastery of the record, or lack thereof, often makes the difference between winning and losing. Anonymous. Not long after I started at the Minnesota Court of Appeals, we had a rather infamous case. Larry Craig, a senator from Idaho, had been arrested for lewd conduct in the men's restroom at the Minneapolis airport. He originally entered a guilty plea via mail. He later tried to withdraw that plea, but the district court would not let him, so he appealed to the State Court of Appeals. During oral arguments on appeal, the judges asked Craig's attorney about a specific part of the record, and the lawyer didn't know what the judges were referring to. Between the attorney, associates, and his clerks, there were at least 7 people sitting at Larry Craig's table, and they were all scrambling to figure it out. The main attorney was left floundering, and it completely threw his case off. All because he didn't know the record inside and out. Step number 5, outline the facts. Marshal the evidence by gathering in one place all evidence on each significant factual issue. Making a chronology helps this. Juxtapose all testimony pertaining to the same event, whether it's from one or multiple witnesses. That way, you will spot inconsistencies. Step number 6. Do your legal research. Dig into the standard of review. What level of deference will the appellate court give to the district court's ruling? You must understand the standard of review applicable to each issue in order to evaluate competently your chances of winning on that particular issue and also to advocate your position credibly. Is this a matter of whether the district court erred in concluding that the plaintiff failed to state a claim? Be efficient. Look for controlling authorities first. For each proposition you assert, try to find the oldest supporting authority and the newest. Generally, you're only going to need one, but finding both will help you see the continuity. Plus, being able to cite both old and modern authorities emphasize the continued validity of the point of law without drowning in string cites. If the law is binding, show how close your situation is to that case. Or if there is a major difference, explain why and how the court should still follow the precedent and rule with you. If it is not binding, then this is where the art of advocacy comes in. Argue why it is persuasive enough for the court to rule with. The key is reasonable comparison. Are the facts similar material facts? Step number 7. Analyze the issues. Try not to learn only the rule of law, but its underlying principle or reason. Think about how the underlying principles and reasons apply to your case and whether they support your position. If you do this, and later base your argument on the underlying principles, you will convey the impression of having justice and fairness on your side, not just legal technicalities. So how do you find the argument that will win for you? Answer these 2 questions. What is the purpose of your brief? Why are you writing it? For the petitioner, this means thinking about what issue or issues will require the appellate court to reverse the judgment of the court below, and what cases or facts precisely address that issue. The odds are against you. As the appellant, you need to grab the judge's interest immediately and never let go. Why was what the trial court did reversible error? For the respondent, you have to consider what issue requires that the appellate court affirm the district court, and what facts or cases support that result. Visualize before you begin. What is the overall message you want to send? Remember that your cornerstone of your argument is anchored on the facts found by the fact finder. What overriding message is the document going to convey? What facts are essential to make the argument? How does the argument take off from those facts? How do different arguments blend together? How should the judge's opinion read if it goes your way? Remember, error by the trial court is not grounds for reversal unless the error could have made a difference in the outcome of the trial. Step number 8. Narrow the issues. Don't use every issue and the kitchen sink. In most cases, you'll want to narrow it to 3 or 4 issues. For your brief, you'll have 1 issue on appeal. Now you'll want to narrow possible arguments in support of that issue to the 2 or 3 that are the strongest in your favor. Step number 9. Outline the brief. Lead with your strongest issue. First impressions count before an appellate court, just as they count before a jury. Appellate judges will expect to find your strongest arguments first. If you place a weaker argument in the first position, the judges will assume that the following arguments are even weaker. Plus, there are risks that a judge may not read your entire brief, or that judge's attention may wander. In fact, there's at least 1 judge on the Court of Appeals who actually tells lawyers that he will stop reading if he does not find the first pages of an appellant's brief compelling. He gives it about 3 minutes. That's it. When outlining your brief, there are a few ways you can do it. You could do it in a standard, linear type format, or you can try an alternative format called whirlybird outlining. Whirlybird outlining is a non-linear way of outlining. A whirlybird is a whirl of ideas resulting from the madman-architect collaboration. This gives the madman an opportunity to develop ideas, while the architect decides what's a major wing and what's just a feather on that wing of the whirlybird. Step number 10. Check the logical flow. Analytical writing is a lot like a flow chart. Each thought should flow logically from the last. Your outline will become your table of contents, which actually may be the first thing read by the court. The outline should present your case in a logical, persuasive fashion. It should also break your analysis into parts. Step number 11, check readability. Readability is enhanced by headings and subheadings that tell a logical story. Headings should be argumentative and explanatory. Not, the court correctly granted summary judgment, but there is no private right of action under the Food and Drug Act. The 12th and final step is narrow your points. You don't want to have too many headings, but at the same time, you don't want what headings you do have to appear to be too broad. From your outline, narrow your points further, especially within each argument. Eliminate weak points and then reorder from strongest to weakest.